this court for 10 minutes. Lastly, court counsel shall within termite our submissions on the fourth legal issues and give our approach to this court. And we would like to reserve 10 minutes for rebuttal. Your Excellency, if you will please this court, I would like to proceed with my substantive submission. Thank you, Your Excellency, and may it please this court. Your Excellency, what becomes the order of the day if digital lives governance systems becomes the tools for committing international crimes? This case is concerned with a former sitting president of the Republic of Cairo who built a digital lives governance systems and later used these systems to starve, terrorize, and kill members of the Butara people. Over the course of our summations, the prosecutions will demonstrate to this court that the defendant is criminally liable for genocide and crimes against humanity, and that the defendant bears superior and individual criminal responsibility. In addition to this, Your Excellency, the standard of proof in this case, it is not to prove beyond reasonable doubt. It is not to prove beyond reasonable doubt, but rather to establish whether there are substantial grounds for this case to move to trial. With that being said, Your Excellency, I will now ask this court endorsement to turn to my first substantive submission. To my first issue, Your Excellency, whether the coordinated killing used by the National Biometric Identity Systems constitute genocide or crimes against humanity. It is the submission of the prosecution that it does. And on this issue, Your Excellency, I will advance two arguments. First, that it constitutes genocide by killing, and second, that it constitutes crimes against humanity by murder. If it pleases this court, Your Excellency, I would like to begin with the first limb of my argument that it constitutes genocide by killing. Your Excellency, Article 28BA of the Malaga Protocol prohibits the killing of protected members of a group with a specific intent to destroy that group in whole and in part. And in addition to this, Your Excellency, Article 6A of the ICC element of crime provides 4 elements that we, the prosecutions, has to establish here today. And these elements are: 1, the perpetrator should kill one or more persons; 2, that this person belongs to a protected group; 3, that there should be a specific intent to destroy this group in whole and in part; and 4, that there should be a manifest pattern. It is our summations that each and every element on this crime are established and certified. To demonstrate, Your Excellency, if you will turn with me to paragraph 27 of the statement of fact on the first issue, between March to November 2022, there were an estimate of 4,300 Butara people who lost their life across 11 districts. It is our summations that this established and certified there were a killing within this case, certifying the first element. Moving to the second element, Your Excellency, whether these people belong to a protected group. Your Excellency, if you turn with me back to paragraph 26 of the fact pattern within this case, it shows that there were a forestry analysis that were conducted across 14 districts within the Republic of Caribbean, and there were a dental and DNA analysis that confirmed that these victims that were found at this gravesite belongs to the Butara community. And it is our summations that the second element is established and certified under this crime. Moving to the fundamental element, which is the intent. Your Excellency, the defense will raise an argument that we are inferring and we are using circumstantial evidence to sustain this element. Agree, Your Excellency. But as the applicable standard in this case, it is not to prove beyond reasonable doubt. It is to establish substantial grounds. And with that being said, Your Excellency, to establish the intent, let us take the defendant's own words into account. Your Excellency, if you turn with me to paragraph 19 of the statement of fact, the defendant stated in his own word, and I quote, "The Butara problem is a generational one, and what previous government failed to address, we will address it permanently and completely, and the tools are now in place. The tools are now in place." And this brought a serious question within my mind, Your Excellency, and I believe it should to you as well. Which tool was the defendant referring to? The defendant was referring to the National Biometric Identity Systems that were launched within the defendant or digital initiative. And this tool has the ability, the demographic model, to classify ethnicity based on their last name. This before the defendant made this statement, Your Excellency, during an executive meeting that were attended by the Director of the National Biometric Identity System, the Person Security Council, and that of the Ministry of Interior. The defendant authorized the Director of the National Biometric Identity Systems to activate what he considered as the Phase 2 ethnicity classification. Phase 2 ethnicity classifications. And when this classification was done, there were operations within the National Biometric Identity System through the Director of the National Biometric Identity System, and these operations were called Operation Clean State. These operations was meant to classify the Butara people based on their locations, their address, and the side they live. So after these classifications through the Operation Clean State was done, Your Excellency, these communications were sent, the register of these people's names were sent through an encrypted file to that of the Director of the Person Security. After these were sent, Your Excellency, if you further turn with me to paragraph 19 of the statement of fact in this case, the defendant himself wrote this following statement in a quote: "The process must be completed before the rain. All names on the register shall be accounted for." Your Excellency, if you observe this statement, there is two must. Must is an order. The process must be completed before the rain, and all names that were on the register shall be accounted for. It is our summations that these statements and the patterns and sequence within this case establish the intent of the defendant within this case. Your Excellency, if you allow me to cite a jurisprudence, in the case of prosecutors for the Kashima, the International Criminal Tribunal Code of Rwanda held that genocide, or it held that when victims' identity and documentations are being used to identify the victims that subsequently led to the killing, it constitutes a genocidal policy. And it is our summations, the National Biometric Identity System constitute a genocidal policies that were meant to eliminate the Butara people, and therefore, under genocide by killing, the defendant bears individual criminal responsibility as pursuant to Article 28N that talk about the most of liability of directing, facilitating, and giving a direct order. All names on the account must be accounted for, and it is our summation that the crime of genocide by killing is sustained based on this fact. Your Excellency, if you indulge me, I would like to turn to the second count of my argument. Moving forward, Your Excellency, to the second count of my argument, it is also our summation that this coordinated killing constitutes crimes against humanity by murder. Your Excellency, Article 28C of the Malabo Protocol requires and defines crimes against humanity by murder by a widespread and systematic killing against the civilian populations with the knowledge of this attack. And in addition to this, again, Your Excellency, there are three elements provided under Article 7A of the ICC element of crime. And these elements are: one, that there should be a killing of more than one person. In my previous count, Your Excellency, as per paragraph 27, I established to the school that there were over 4,300 Butara people who lost their life. Now, to the second element on crimes against humanity by murder, that the killing should take place as a widespread and systematic killing. Your Excellency, if you further turn with me back to paragraph 20, or if you turn with me back to paragraph 10 of the statement of fact, these killings are happening. It happened across 11 districts. There were 7 within the southern and 4 within the eastern. It is our summations that these killings were a widespread and a systematic attack. And now to the last element, Your Excellency, that the defendant should have knowledge to this. And this is very important, Your Excellency. Or men who quote that the Butara problem is a generational one. We have the audacity and comes to this school that he does not know about this attack that happened within this 11 district, where 4,300 Butara people were killed. 11,000 were displaced. Your Excellency, these people were not just killed by gun. These people were killed by knife. These people were killed by college. Take a moment and think about that, Your Excellency. 4,300, 11,000 being displayed. Your Excellency, it is our summations that the defendant knew about this attack, and the defendant had knowledge that this attack was happening. If you turn with me to paragraph 25 of the statement of fact, there were 2 commanders within these districts that testified to the national inquiry on confidentiality, and they said that they received the register that were generated through Operation Clean State. And they also said that this or their commander told them to neutralize all names that were on that register. Your Excellency, the chain of command within this case is clear. There were a order, there were a sequence. And Your Excellency, one important thing I want to notice to this code is that the defendant gave the order that all names on the account should be accounted for on March 7, 2022. And after he gave that order to that communications, the killing happened right after. This is not a coincidence, Your Excellency. All of these facts establish that there are substantial grounds. Your Excellency, if the prosecution comes and says that this is not a substantial grounds, then I wonder what it is, Your Excellency. Your Excellency, like I said, 4,300, 11,000 being displayed. 2,800 were later killed as a result of the deprivations of food, which my co-counsel will also address. These are serious concerns. There is a reason why the law characterized genocide and crimes against humanity as a grave crimes known to our society. Your Excellency, the only difference that is between this case and is your indulgement, because what I'm about to say is very sensitive, is your indulgement. The only difference between this case and what happened within Rwanda, the 1994 genocide, is that in Rwanda, there were no AI systems that were used. But within this particular case, they digitalized everything to be able to kill these people. And it is our summation that the defendant is individually criminally responsible and bears superior criminal responsibility. If this court has no further questions for me at this time, that does it for my summation.
You can proceed with the next question.
May it please this Honorable Court, Your Excellency, I'm by the names of Kamikaze Leticia Divine, and I'm the second counsel on behalf of the prosecution side. Your Excellency, I'm here to present the second legal issue and the third legal issue. If this Honorable Court allows me to, I would like to proceed with my second legal issue. The second legal issue states that the state-directed deployment of AI-generated deepfake campaigns causing severe psychological harm to civilian population constitute genocide or crimes against humanity under international law. Your Excellency, I have two counts on this legal issue. The first count will be that the AI-generated deepfake campaign constitutes crimes against humanity of other inhuman acts, and the second count will be AI-generated deepfake campaign constitutes crimes against crimes of genocide by causing serious mental harm. Your Excellency, I would like to proceed with the further pleading of this legal issue. Your Excellency, the prosecution respectfully submits that Jean-Pierre Havugimana is individually criminally liable for the crimes against humanity according to the Article 28C, paragraph K of the Madrabo Protocol, which prohibits, of the Marable Protocol, which criminalize causing a mental or a bodily harm to a certain group or a civilian will be considered as a crime against humanity. Your Excellency, with the further pleading, I would like to show this honorable that different actions Jean-Pierre Havugimana has committed which leads to this inhuman act. Your Excellency, according to the paragraph 14, in the meeting, the President, Your Excellency, if you allow me to, why change the microphone? Thank you, Your Excellency. According to the paragraph 14, it shows that the President provided authorization to execute the transfer of data through the channels, and they were being treated as the highest documents of... Your Excellency, before, the President just introduced the National Digital Health System,
which was so called to be called that was a digital system was about healthy, providing health services equity, fairly to the citizens of Karuba Nation. But later, this National Information Management Center, in this initiative, was established under this digital system. Your Excellency, according to the Article 12 of Universal Declaration of Human Rights, it states that no one should face arbitrary interference with their privacy, family, home, or everyone. They has a right to the legal protection. This means when the president just said that he wanted all those data that were recorded to go directly to him, while the people of Karuba and Batura, they did not provide their consent to provide those biometric data. It means that they were interfering within their privacy, and there were not any legal protection over their rights. Your Excellency, the second count, it will be like to be dehumanized in the hate speech circulated on the radios and TVs. Your Excellency, according to the paragraph 29, the Batura people were called the parasites that had fed on the country for too long, and they needed to be removed. Your Excellency, the Article 6 of Universal Declaration of the Human Rights and the Article 16 of ICCPR, it states that every individual has a right to be recognized as a person under the law. Your Excellency, let's take this moment and emphasize on if you are in your own country, your own nation, you are born there, you're called a citizen of your own country, and then now you're started to be called that parasite that has fed on the country. It means that you're not only you're not even a human, you're something else. And here already they have already taken your right to be called a human being. It means that they've already dehumanized you. You're not a human being. You're recognized as a parasite that is feeding on the nation. Your Excellency, this goes also on the second count of AI-generated campaign constitutes crimes of genocide by causing a serious mentally harm, which means that when the people they were regarded as a parasite, it started harming them psychologically, Your Excellency. Which means that if you're an actual parasite, like they were so-called here in the case, it means that how are you going to operate in your country? Because people will be looking at you as a parasite. And Your Excellency, in the case paragraph 30, the government was asking the other citizens to help them to make sure that they cooperate with the government to make sure that these people of Batura, they are just discriminate them. They are discriminating them, Your Excellency. And this fact of a discrimination is one of the stages of genocide that makes up a genocide, Your Excellency. Another fact, Your Excellency, when they were correcting their biometric data, the elders of Batura ethnic group, they took initiative to say, they went to the provincial officers. They submitted their complaints, asking for the details of this system because they wanted to know more about it, because they were going to provide their data, their private data to the government. They wanted to know what this system was made up of, how their data are going to be protected. But later, the government did not answer it. Yet they submitted to it. And this goes to the Article 19 of Universal Declaration of Human Rights, which states a freedom of opinion and expression and the right to the truthful information. Your Excellency, these citizens really needed to be given the truth about what was happening within that campaign. And how, Your Excellency, going further, there are clinical investigation report that was conducted, which showed that the people the population that were affected from the late 2021 through the mid 2023, this record showed that people were severely affected, and it was on the widespread of the mental health. Your Excellency, this shows that this AI generated deepfake campaign caused a lot of suffering to the people of Bathura ethnic group. Your Excellency, if you allow me to, I would like to tell this honorable court to consider this fact. Being born in your country, first of all, is a pride. To be called, people are very proud of their country, of their originality. Once you're started to be called a parasite, that you need to be removed very quickly because you've been feeding on your country. Your Excellency, this shows that these people, exterminating them, this was really planned. It was something that was planned, and then they used this AI generated deepfake campaign to correct their data, not only first harming them mentally, but also proving to the world and to the citizens that they were not even human beings. This affected them not only strategically, this affected them, Your Excellency. It showed that people were not even able to function, to live in the normal life that they used to live in. Your Excellency, if this honorable court allows me to, I'd like to, if they have, the honorable court does not have further questions for me, I would like to call my counsel. Thank you, Your Excellency, much obliged. The relationship that shows that AI-generated deepfake campaign caused a lot of psychological problems, harm to the civilians, or to the people of the Bathura ethnic group, is that these people, through this AI-generated deepfake campaign, there were records of their elders that circulated around, telling them to deny their own identity. Your Excellency, if one of your own leader, one of your own ethnic group is asking you to deny yourself so that you can be able to live in another society, this means that they are already showing you that you are nothing. Being called a Bathura ethnic group, it means that it's like a disgrace. Your Excellency, as a human being, to understand that you're a disgrace in the community, this is such harmful thing by person by thinking like that. This means that this generated AI campaign, it caused a lot of harm by making them thinking that they are disgrace. Your Excellency, how it is related to him by himself, it is because he had each records that was being recorded at the field. He got through this system. He was the one who authorized to have a secrecy, a confidential, where they had to pass direct report of what happened. Your Excellency, this means that he acknowledged that the people of Bathura were being called parasites. Even those audios, fake audios, they were aired on the national TVs, Your Excellency. Means that as a president, he already knew that, but he did not do anything, which means he's individually criminally liable, Your Excellency. For the further question you asked me, I think, Your Excellency, my next counsel will answer that. Thank you.
May it please this honorable court. My name is Sharon Kawatesi, and I'm the third co-counsel on behalf of the prosecution. And I'm going to present the fourth legal issue, after which I'll present the prayers for the prosecution. Before I proceed, I would like to answer the question that was asked to my co-counsel, whether to link what happened to individual responsibility of Jean-Pierre Havugimana. Your Excellency, if you turn with me on paragraph 14 of the Statement of Facts, it states that the minutes of the January 2021 Security Council meeting record Havugimana directing the Director General of the NBIS to activate what he ordered as Phase 2 ethnic classification protocols. Your Excellency, apart from only this, when they were putting in place the NIMC, they hid the aim that was actually behind it. They said that the initiative was to publicly describe a government communication infrastructure that was intended to support public information campaigns and improve the engagement of the government with the civilians. However, what they did not disclose to the population or the public is that in paragraph 12 of the Statement of Facts, it says that what was not publicly disclosed to the public was that it was later established by the National Inquiry what was the NIMC had been equipped with the AI synthesis tools capable for generating photorealistic synthetic audios, video, and text content, including voice cloning and facial animation technologies. Your Excellency, if the government itself believes that this technology is it is for the purpose of what they actually said, why are they having an aim that they are not disclosing to the public? This creates an intent of the Jean-Pierre Havugimana, which makes him liable. And also the directive that was on record, that was given to the Director General in order to put in place the Phase 2 of the ethnic identification, makes him individually liable. Your Excellencies, if it pleases this court, I'll proceed. I'm going to present the fourth legal issue, which says the algorithmic deprivation of food and medicine, whether it amounts to crimes against humanity of extermination and also persecution. Your Excellencies, I'm going to show this honorable court that what the suspension of food and medicine in these free zones of Mwanza, Kenda, and Beriza, what happened is actually amounting to what is called termination as a crime against humanity. Your Excellencies, if you check with me Article 28C, Section 1 and Paragraph B of the Malabo Protocol, it defines extermination as intentionally inflicting conditions of life on people with the intention of distracting them. Your Excellencies, if we see what happened in this case, we see that in Article 11 of the ICESCR, there is the right to life, the right to food, sorry. And here, it was deprived of these people. The people were feeding on food. All of a sudden, it is suspended. In the African Charter of Human and People's Rights, on Article 4, on the right to life, people who were depending on medicine, people who had HIV depending on antiretrovirals, were not receiving them anymore. People who were depending on insulins, the diabetic people, were not receiving the medicine anymore, which means that they are being deprived of their rights. Your Excellency, we see that this attack was on 3 people, and the concealment, maybe the defense will say that the suspension was because of flooding. However, Your Excellencies, we see that in paragraph 45 and paragraph 46 of the Statement of Facts, the audit that was made by the National Inquiry itself states something different. If you check with me paragraph 45 and 46, it states that there was no flooding at all. The vehicles that were transporting food and medicine were very ready, but they were not operating. The roads were passable and there was no issue at all, which means that the government was creating a cover for itself to say that it was flooding, yet it was not flooding. Your Excellencies, if we link this to Jean-Pierre Havugimana, it's because it is his government that is creating cover, and it is this same government that is in issue 2 creating the same office that is in issue 2 with the deepfake campaigns. If I proceed with my second legal issue of the persecution, in Article 26C, paragraph 1, subsection 1 and paragraph H, we see that there is what is called persecution, which is the privation of fundamental rights of human rights. And here we see that people were deprived of their right to health. Thank you. If it pleases this Honorable Court, I would like to ask for 30 seconds so that I can conclude with my submissions. Thank you, Your Excellencies. And if I proceed with the prayers of this Honorable, the prayers of the prosecution, for the foregoing reasons mentioned in issue 1, issue 2, issue 3, and issue 4, the prosecution respectfully prays that this Honorable Court confirms the accused, Jean-Pierre Havugimana, that we bear substantial grounds to believe that he is criminally liable or responsible of these crimes. Second, to confirm that the charges of genocide, and including genocide by killing, genocide by causing serious mental harm, genocide by deliberately inflicting health conditions, and to confirm charges against humanity, including murder, persecution, and other inhuman acts. We also pray to this Honorable Court to order that this matter be committed to the trial chamber before the trial chamber of this Honorable Court, and any other relief that this Honorable Court deems just and in the interest of justice. Thank you. That was all for the prosecution.
I want to ask a question to the prosecution. I look forward to getting an answer. Within your prayers, you've just mentioned that we should also acknowledge genocide that was done through antagonizing their people from Karuba's mental health. Can you please elaborate the threshold of mental health, the mental harm that was done? It is to what extent? And why should the court consider the prayer specifically?
You answer that question when you come for rebuttals. You still have that time, note your question, you'll be back to that.
So let's proceed with the second question that you will also answer as you come to the rebuttals. Counsel, you may proceed.
Okay, the prosecution in your submission, we have seen you rely a lot on digital evidences, those biometric registers, AI-generated content, server logs, internal communication, and metadata. I want to know how has the prosecution established the authenticity and the integrity of those digital evidences? Why should this trial rely on those evidences to prove the aspect of individual criminal liability for Jean-Pierre Havugimana? Yeah.
The defense, you can proceed with your. Yes, you have 30 minutes uninterrupted, and then you will also have 10 minutes for rebuttals. This is your time. The defense team code is MCF-2026/05D, and the names of the people who are on the defense side, we have Calvin Angelo, is seen this way, and Rosindana Wase Vicky. You may proceed.
May it please this Honorable Court, Your Excellencies, Madam President, the prosecution will have you believe that there was dorus specialis required for genocide and material elements for crimes against humanity. But first, before we go deep in the facts, let's first look in the background of the case we have. Your Excellencies, in paragraph 4 of the statement of facts, it shows us clearly that the Republic of Karuba was a Huza-dominated state, and they've been marked, and national reconciliation process was initiated in 2009, which produced a national apology from the government in regards to the abuses that have been being done in the year between 1991 and 2003, Your Excellencies. Your Excellencies, the accused, you see, Mr. Jean-Pierre Havugimana, the former president of the Republic of Karuba, was born in 1967 in Kaluba City from the same Huza family, which was a state-dominant ethnic group in the Republic of Karuba. Back to 2019, right after he went to the presidential tenure, he introduced 3 AI algorithmic systems that were initially supposed to help in enhancing digital governance of the Republic of Karuba, Your Excellencies. As a person who had background in digital communications, he introduced these tools. So there are many negative things that happened during his presidential tenure, but then we do not construe them as neither genocide or crimes against humanity, as the prosecution has failed to establish dorus specialis required for the crimes of genocide and material elements for the crimes against humanity, Your Excellencies. Your Excellencies, in September 2021, the deep fakes they talked about, it was clearly established by the Ministry of Communication in the Republic of Kaluba that it was a result of an intrusion and cyber attack that was done to one of the systems that was initially implemented or put in place to enhance the digital governance of the Republic of Kaluba, Your Excellencies. Your Excellencies, in the meantime, while the former president of the Republic of Kaluba was still looking for the solutions to what was being happening, and in regards to the former apology that was done to the Batula communities in 2009, which was not considered in anything as the government. So the accused has been really integrated to continue that former apology in practice and in regards to Your Excellencies. Your Excellencies, in March, coordinated killings in 11 districts of the Republic, killed approximately 4,300 of Batula communities in displaced 11,000 people. Your Excellencies, on 7 March 2022, the accused, which is the thing that the prosecution is basing on, has released a message which says, coming back on paragraph 19 of the statement of facts, it says, Batula problem is a generational one. The government, what has not been addressed by the previous governments permanently and completely, we will address it permanently and completely. Your Excellencies, coming back to paragraph 4, it says, the relationship between Batula and Huza-dominated state has been marked across Matiko administration by patterns of political exclusion, land dispossession, and periodic targeted violence. So, Your Excellencies, that national reconciliation process, which was initiated in 2009, has produced a formal apology from the government for abuses that happened between 1991 and 2003. But the federal governments did not act upon that. So in this regards, on 7th March 2022, the accused has said that that program of Batula programs are facing a lot of problems from unidentified people in regards to that defects that have been a result of cybersecurity attack into one of the systems that were established to improve the digital governance of the Republic of Kaluba. Your Excellencies, if it pleases this honorable court, the defense would like to proceed with the statement of facts. Your Excellencies, the accused primarily has background and reputation in senior planning within the Ministry of National Development. So in that reputation that he has earned, he favored him to centralize and data governance as a model of public administration. Shortly after 2019 inauguration of him, the accused, the former president of the Republic of Karuba, has announced the Digital Governance Initiative, which was establishment of National Digital Health Management System, National Biometric Identity System, and National Information Management Center. Your Excellencies, on January 14, 2021, the National Security Council convened to address a destabilization campaign which was being perpetrated by ethnically motivated opposition networks in the northern and the eastern provinces. In response to those threats, the accused has authorized to use the very same system that was put in consideration to enhance the digital governance of the Republic of Karuba, which was National Information Management Center. So these registers were classified as the highest level of state secrecy and were intended strictly for designated provincial security commanders to identify and neutralize those specific individuals who were raising this campaign, which was perpetrated by ethnically motivated opposition networks. It was not those registers, they were classified as on the highest level of state secrecy and were not intended strictly for designated provincial security commanders to identify and neutralize specific individuals, not ethnic groups, Your Excellencies. And it was those specific individuals that were going to be neutralized. There are the same people, the very same people, which were assessed as people who are posing threats, direct threats to the national security, Your Excellencies. So there is no documentary evidence at all in the statement of facts, which shows clearly that the president gave an order to kill, and instructions were conveyed verbally in relation to the normal counterinsurgency operation procedures that are followed in the Republic of Karuba. Your Excellencies, in January 2021, the National Digital Health Management System has operated what was called Resource Allocation System Prioritization Framework, which allocated medical supplies according to objective metrics. Part of them was geographic remoteness, economic productivity, health system capacity, and civic stability index. Your Excellencies, in September 2021, the deepfake campaign has emerged on social medias and was later on addressed by the Ministry of Communications in the Republic of Karuba as a result of cybersecurity attack that was done to the to the National Information Management Center as one of the tools that were put in place to address the problem of Karuba, the Republic of Karuba not having enough digital governance systems. Your Excellencies, if it pleases this honorable court, the defense would like to proceed with the issues of today's case. Thank you, Your Excellencies. The first issue is whether the use of AI-powered biometric system to compile ethnic targets, registers that were used in coordinated killing constitutes genocide or crimes against humanity under international law. Your Excellencies, the use of National Biometric Identity System was a standard data-driven security measure within a legitimate counterinsurgency campaign. To those people who were identified as posing a direct harm to the Republic of Karuba. And it is one of the most important responsibilities of the government to protect its citizens. So when we see a person posing a direct threat to the national security, we have to act effectively immediately, Your Excellencies. The defense submits that the prosecution cannot establish the specific intention, which is dolus specialis, to the particular specific individuals, but rather the accused, former president of the Republic of Karuba, when he talked about, in the paragraph 19 of the statement of facts, that particular problem is a generational one, it was about what was later on talked about in paragraph 4, which was not put in consideration. Your Excellencies, continuing on that, genocide in nature requires the highest level of specialists, Your Excellencies. So the activation of demographic registers, which was done within National Identity System by the government, by the Republic of Karuba, was not ethnically motivated, was not an ethnically motivated campaign, and should be read as an ambition towards state stabilization and peace, Your Excellencies. Your Excellencies, in the case law of prosecutor versus Turkish, statements regarding political stabilization of a region were not treated as equivalent to a specific intention to physically destroy a demographic group. Further, the instructions concerning the registers, they were confined later on to identifying and screening individuals assessed as direct threats to the national security. Your Excellencies, we have provincial commanders who have cooperated as the statement, in the statement of facts, Your Excellencies. So they have confirmed to the national inquiry that there was no specific order to kill that was issued by the accused, and that the subsequent attacks were carried out by armed groups operating on their own initiative, Your Excellencies. The very same people that the prosecution is trying to make us understand that the president gave them a direct order have confirmed to the national inquiry that people who killed these people were armed groups, and they operated on their own initiatives, provincial commanders. Your Excellencies, again, as established in prosecutor versus Bagirishema, an executive leader cannot be held strictly liable for the autonomous criminal conduct of a subordinate or third-party actors that breaks a direct causal chain of command. So the accused, accordingly, cannot be held criminally liable for the conduct that the prosecution is pursuing here. If it pleases this honorable court, the defense would like to proceed by submitting the second legal issue. The second legal issue, Your Excellencies, is whether the state-directed deployment of AI-generated deepfake campaigns causing severe psychological harm to a civilian population constitute genocide or crimes against humanity under international law. Your Excellencies, the toxic deepfake cannot be legally attributed to the accused because official documentation confirms that National Information Management Center was the target of that cyber attack at the relevant time. Furthermore, the international law does not recognize psychological distress caused by digital media broadcast as constituting genocide, neither crimes against humanity. Your Excellencies, the state-directed deployment of AI-produced media, even if it caused the psychological distress, it falls outside the statutory definitions of genocide and crimes against humanity. In the Article 28B of the amendments on the Protocol of African Court of Justice and Human Rights, which is the court we are appearing before today, says that the statute requires the infliction of serious bodily or mental harm. An instrument in jurisprudence explains serious mental harm that's something that has been understood to require profound and lasting impairment of human dignity, typically accompanied by physical torture, threats of imminent death, or severe physical trauma. Your Excellencies, not exposure or access to disinformation that was done by the third parties who hurt the National Information Management Center. Your Excellencies, while clinical presentations documented that among Batula population, however serious, it does not amount to the physical destruction of a group, which is what constitutes actus reus for the crime of genocide. Your Excellencies, for the prosecution to ground crimes against humanity, the accused, the conduct must form part of a widespread or systematic attack which was directed by the state, as it is said in the Article 28C of the Amendment on the Protocol of African Court of Justice and Human Rights, Your Excellencies. So the accused cannot be directly linked to the distribution networks of the campaign. Furthermore, the Ministry of Information Communication formally documented unauthorized distribution networks of the campaign. So, Your Excellencies, a contemporaneous state report has created a reasonable doubt to exclusive internal command and undermines any assertion that the campaign was official state policy that was initiated by the state. So, Your Excellencies, as the prosecution is trying to make us believe that the accused, Mr. Jean-Pierre Havugimana, the former president of the Republic of Ghana, had intention to kill in whole or in part to satisfy the material elements for the crime of genocide. Rather, the accused was trying to act on the government, the excuse the government community, as was rather established in paragraph 1, where they introduced a formal apology to the Republic, to the individuals of the Batula community, Excellencies. If it pleases this honorable court, we would love to allocate the remaining time to the repartees.
Before you proceed, how do you respond to the testimonies, okay, of the provincial security commanders who confirmed receiving the registers, okay, and the briefing that they were to identify and neutralize the threat?
Your Excellencies, the testimonies that were given by the provincial leaders, as we've said about it in the statement of facts, the provincial leaders who cooperated, those who were provincial security commanders, have said that they have received, confirmed to the National Inquiry that there is no specific order from the president to kill the specific individuals that were in the registers, and rather said that it was done by armed group which operated on their own initiatives.
Before you answer my next question, I'm going to ask you to close your laptop, as well as your fellow counsel. Thank you. Can you please?
Yes.
So tell me, isn't this coupled, okay, like, isn't this coupled with the identity-based nature of the attacks?
May I beg your pardon, Your Excellency?
According to the previous question that you're answering,
Yes.
isn't this coupled with the identity?
Testified that the people who killed the 4,300 Batula individuals were not from their order, but rather were acting on their own initiative. So we don't see how the prosecution is linking this with the accused, the former president of the Republic of Ghana, Your Excellencies.
Okay, maybe a follow-up question. Then, how do you demonstrate an evidence which shows that the president of Jimana neither directed or authorized or knew about those killings you are saying which were done by the commanders? Which evidences do you like to submit to this trial court?
Paragraph 18 of the statement of facts says that the province must be addressed before the reigns, Your Excellency. If you see the dates that was dated later after the killings of the 4,300. So then that means that the problem was there, the president knew it, and he was asking the provincial leaders to act upon and stop that killings. Rather, the prosecution is trying to establish intention that the president was targeting the specific individuals and killed them.
Okay. So you are saying that the president knew, but what did he do afterwards? If he knew that the killings were being done?
Much obliged, Your Honor. The president knew that what was going on in his country, which is why they used those registers to say that these people have to be protected, not be killed. Because there is no direct order from the president who says, go kill these people from the registers that you have received as provincial leaders. And in their testimonies, like I have said before, they said that the former former President of the Republic of Karuba, Mr. Jean-Pierre Havugimana.
You're not going to use it.
Mr. Jean-Pierre Havugimana. If it pleases this Honorable Chamber, I would like to proceed to issue 3 and 4 in my submissions. Issue 3 is regarding the NDHMS system that was set up by Mr. Jean-Pierre Havugimana. This issue, I will note, prior to my subsequent arguments, was not well tackled or substantially argued by the prosecution. The NDMHS resource prioritization framework does not satisfy genocide under Article 28B and crimes against humanity under Article 28C of the Malabo Protocol, since there was no ethnic targeting through these systems. A primary element of genocide is direct intent. However, this was not established by the facts, and in fact, we have paragraphs 38, 36, and 37 of the fact sheet showing us that the government construed that the NDHMS system was well functional and ethnic in delivering the purpose for which it was established. I'll further proceed and say that Prosecutor versus Garlic established and will help this chamber to establish that there was no specific targeting of civilian populations in the lack, as the prosecution will have us believe, in the shortcomings where medication and different supplies were to be delivered. Administrative shortcomings and unanswered complaints or divergent healthcare issues amount to a governmental failure or shortcoming, not an international crime under the Malabo Protocol, Article 28B and 28C respectively. I'll further proceed to issue 4 if the chamber sees so fit. Issue 4 speaks on the algorithmic allocation of healthcare, speaks on the fact that algorithmic allocation of healthcare reflects sovereign socioeconomic policy and not a systemic attack. The NDHMS, sorry, that was issue 3. Apologies to your excellencies. I'll proceed with issue 4. That states that the supply suspensions to Mwara, Kenda, and Biriza were justified by environmental factors. The suspension of deliveries to the 3 zones does not satisfy extermination under Article 28C or genocidal destruction under Article 28B of the Malabo Protocol. In fact, if I will direct this Honorable Chamber to paragraph 43 that shows us that the locations as presented in the fact sheet, Mwara, Kenda, and Biriza were not locations that were inhabited by the Batura community. Mwara, Kenda, and Biriza were central western province constituencies, inconsistent with the locality of the Batura people, as the prosecution would have us believe that the Batura were direct victims of this inconsistency in supply chain. I'll further proceed and say, extermination requires the intentional infliction of conditions of life calculated to bring physical destruction. This is laid out in the case of Prosecutor versus Laurent Gbagbo and Charles Blegood, which was decided on the matter as reiterated. Here, the Ministry of Public Infrastructure confirmed that the route disruptions were caused by seasonal flooding, rendering transit networks impassable. This is also, I will come back to what was reiterated in the statements my co-counsel constantly brought back in front of this chamber in paragraph 19, that the Batura problem was to be addressed before the rains. Clearly, this was a customary experience with the Karuba government, that rainy seasons could cause inconsistencies, and hence they were addressing that issues consistent with supply should be addressed before then. And clearly, not the Batura people were affected by the inconsistent transportation failures, but the people of Mwara, Keda, and Biriza. This irrevocably removes the context of intent or dolus specialis required as a threshold for the crime of genocide under the Malabo Protocol, and also crimes against humanity lack the substantial grounds to be considered by this honorable chamber. The rerouting of vehicles through the central NDHMS logistics module, which, as I will remind this honorable chamber, was deemed efficient in paragraph 36 and 37, reflects an algorithmic adjustment to protect state assets from flooded sectors or potentially flooded, sectors that could be potentially flooded, not a plan to starve a civilian population. Individual criminal responsibility requires mens rea, which is the technical logs that trace the authorization from the suspension module to a credential assigned to the senior digital operations advisor. The accused did not execute this configuration himself. And we see that no evidence shows that his contemporaneous knowledge of the specific parameters affecting these three zones was an issue. The arrest of independent operators distributing medicines outside the NDHMS framework was carried out under general public health regulations designed to prevent unvented pharmaceutical distribution. Standard regulatory enforcement, not an execution of criminal intent. If it pleases this honorable court, I submit these two issues as presented by the defense and would like to proceed to the submissions of the defense. Our submissions are, for the reasons set above, the defense respectfully prays that the pretrial chamber of the International Criminal Law section of the African Court of Justice and Human and People's Rights dismiss all the charges brought against Jean-Pierre Havugimana for genocide and crimes against humanity on the ground that the prosecution has failed to establish sustainable grounds to believe that he possessed the necessary specific intent or exercised requisite command oversight. Furthermore, we would pray that this court declare that the implementation of algorithmic governance platforms and demographic registries in the context of national security review does not, without more, and I emphasize, without more, constitute an international crime under the Malabo Protocol, specifically Articles 28B and 28C. Finally, we pray that this court order the immediate termination of these proceedings and the unconditional discharge of the accused on the grounds that the prosecution has failed to establish reasonable grounds. May it please this honorable court, I would like to allocate the remaining minutes to the answering of questions and rebuttals.
thought there were no more minutes, but there are two communications that are of high importance that I want the Defense Counsel to respond to, that we are connecting with the accused. There is a communication that was traced from a server from the Office of the President, Mr. Jean-Pierre, that said that the process must be completed before the rains. All names on the registers must be accounted for March 2022. And what previous governments failed to address permanently and completely, we will address permanently and completely as stated in November 2021. What is the position of the Defense Counsels on this statement from the President himself?
The position of the Defense Counsel, Your Excellency, thank you for your question. It is a very enlightening one and one that is going to help the defense to establish its case before this honorable chamber. The position of the defense is that this communication, as reiterated, addressed multiple questions. I'll refer back to further communications and facts as presented in the fact sheet, particularly the facts represented in paragraph 4 of the fact sheet, and also the facts represented in paragraph 43. The facts represented in paragraph 4 are relevant to this statement because we see that previous governments had, in fact, had a very terrible standing with the Batura people. And the accused is seen to be saying, consistent with the apology issued by the government of the Batura-dominated state, that the problems that the previous governments were not able to address, they would address permanently and completely. This leaves no room for us to insinuate or bring suspicion that he was saying this in bad faith. In fact, it shows that consistent with the apologies that were issued in that same paragraph, paragraph 4 that is, they were trying to eradicate a problem that had been there. And furthermore, the names of the registry that are consistent with what the statement says or the communication were to be used to, as my co-counsel reiterated, protect or try to protect the Batura community, which was suffering killings from unknown people or people who were not affiliated to the government. Furthermore, paragraph 19 will also help us to see that this problem was consistent with the issues later reiterated in the government. While independent bodies that did logistical audits show that there were no rains, we see that the government had reasonable grounds to foresee rains as was custom. And this is so because such a statement was made way before paragraph 43 came into play. So we see that this statement was not very particular to the fact that there was going to be killings orchestrated by the government to the Batura people or such harm committed towards them, but rather showing that the government was making its best efforts and putting its best step forward in resolving the Batura issues as is consistent with the facts.
Council, you may be back to this when you come back for rebuttals, but issues of linguistic and how officials make statements may not necessarily come out clear that we are enlisting these people to be killed. We have very many examples that we can refer to. Most of those campaigns may not necessarily bring it out that we are intending to kill these people. But when those lists are used for another purpose, which ultimately caused the deaths of those individuals, we cannot take this for granted. Bank the question, we'll be back to it when you come back for rebuttals. Thank you.
May it please this honorable chamber rather, I would like to submit that the defense rests and we'll be back for rebuttals. Thank you.
We are calling the prosecution for rebuttals, and note that you have 10 minutes for rebuttals. Kindly include all the questions that you've been asked by the panel of judges, as well as the inquiries that were sent by the defense Team, this is your time. You can start.
Thank you, Your Excellency, and may you please this quote. So for rebuttal, I will use 6 minutes, and my two co-counsel will share the remaining 4 minutes, 2 minutes each. Your Excellency, before I move forward to the rebuttal and get inquiry, I would like to answer Her Excellency Mujisa questions on the issues of the antithesis of the evidence we presented, the text messages and everything. To this, Your Excellency, after this entire incident happened within the Republic of Caribbean, there were a national inquiry commissions that were commissions to investigate these series of events that happened within Caribbean. This national inquiry reviewed over 240,000 documents that include all the statements that were made by the defendant, and they also interviewed over 315 witnesses. So the issues of the evidence that we are bringing, they are factual as they were brought forward by a national inquiry commission. Now, Your Excellency, moving to rebuttal. On the next questions, my co-counsel will address that. Moving forward, Your Excellency, what has the prosecutions established? The prosecutions has established that there were intent, knowledge, and control. And what has the defendant acknowledged in this case? Let's look at the chain of command. The defendant has acknowledged that this register that was generated through Operation Clean State were received by the Province of Security Commando. They did not deny that. The chain of command within this case has been established. So now, coming back, does the defendant within this case have effective control over the commander? Of course he does. He has the effective control over them. The defendant has knowledge of that. The acceptance by the defendant to agree that this register was received, it shows that the defendant knew about what was going on. But yet the defendants want this court to believe that they intended to protect. Your Excellency, that sounds very harsh to me. To protect the 4,300 people died. If they were not protecting, Your Excellency, how many was going to die? Maybe 10,000, Your Excellency. What we have established, this case is, Your Excellency, the intent has been established. And the prosecutions keep saying substantial grounds. Substantial grounds is a grounds that we have to show the reasons, we have to show reasonable fact, and we have did, Your Excellency. The burden in this case is not beyond reasonable doubt. If it were beyond reasonable doubt, then that's the time. If it were beyond reasonable doubt, the court now could have asked for us to polygraph the defendant to see, test rating on his heart that are intended to kill the Butara people. But in this case, the substantial grounds has been established. Secondly, Your Excellency, the defendant also want to bring the issues of apologies. This apologies does two things. One, it established that there has been a dispute between the Butara and that of the Husu. That's the first thing it does. And secondly, the defendant too also wanted for this court to believe that this apologies was an issue to settle reconciliation. No. Let's look at the timing. This apologies was made in 2009. When this incident took place, it happened between 2021 to 2022 in the course of 9 months. Are we seeing the time differences here, Your Excellency? In 9 months. In 9 months, there were a digitalized governance systems, the National Parliamentary Identity Systems, the National Information Management Systems, and that of the National Digital Health Management System. In 9 months, there were registers that were generated through Operation Clean State and were sent within 9 months. And one thing, Your Excellency, that really gets me confused to the defense defense here today is that these communications that His Excellency stressed on, that all names should be accounted for. And indeed, Your Excellency, language is very important. If you look at this sentence, there were 2 musts. The process must be completed before the rain. And when we look at that of the Great Lake regions or area, usually the rains happen after March in April, moving forward. Then secondly, he also emphasized on must again. All names on the register must be accounted for. There is two must that he have established here. And what does this do, Your Excellency? It shows that they intended to kill those Butara people. And it should offend Your Excellency where 4,300 children, women are being killed, and the prosecution says that they want to protect their citizens, Your Excellency. It's offensive. It's offensive. We have established the intent. The defendant has accepted that the defendant within this case has control. We have established the knowledge. We have established the effective control. And therefore, Your Excellency, even if this court found that the issues of intent is not established, crimes against humanity can also be established. And we are not saying that because all of these two crimes that we have brought has been established. There are substantial grounds. The applicable standard in this case is substantial grounds. Your Excellency, I'm offended.
Counsel, you're offended, but the court wants to understand fully the responsibility that you are establishing against the accused, especially in this context of digitalization, where we have seen that deep fake campaigns have been orchestrated in this context. How about if the defense argues that the enlisting processes and everything else linked in these statements were AI generated, which they would not want their client to be accused of? So try to establish the personal responsibility of the accused before this court, before you leave the bench.
Thank you, Excellency. To establish this, Your Excellency, the National Information Management System, to make it very short, was under the office of the defendant within this case. It was not operating separately. And this is one of the inconvenience things. How would the National Information Management System be under the office of the president? So he had knowledge of this attack and these deep fake campaigns that were happening. Your Excellency, you are judge and you have your secretary. You have your secretary. And your secretary is doing something that is illegal. And now you are being investigated. Will you tell the body that is being investigated or that is investigating you that your secretary is fully responsible for that illegal activities that you are being investigated for? No, it's your responsibility to know that. Thank you, Excellency. My co-counsel will then clamorize on the remaining minute. I'm offended, by the way.
May it please this honorable court, Your Excellency. On defense side, the counsel say that we did not provide the fact that shows in the statement that there were no severe psychological harm. Your Excellency, if you turn with me on the paragraph 34, yeah, it shows that field health workers operating in Batura communities in Northern East Province within working the right-based community based community documentation framework promoted by the civil society
conducted a clinical assessment of affected population from the late 2021 through the mid-2023. Their records document a severe and a widespread, Your Excellency, mental health crisis across the communities. I don't think, Your Excellency, if this court approves me, I think the defense did not understand the definition of severe. Maybe they could go deeper in research and they know the meaning of severe. Like he said that there was no severe harm. So in the statement of the case here, they are saying that there was a severe harm. Your Excellency, I would like my counsel also to come to continue with her.
May it please this honorable court. I would like to respond to what the defense said on the issue of legal 4, which talks about extermination. Your Excellencies, the defense said that there was no extermination or grounds of extermination because there was no intentional infliction of conditions of life. However, Your Excellencies, if you turn with me on paragraph 45 and paragraph 46 of the Statement of Facts, we see that people were deprived of their rights to life and rights to health. Your Excellencies, and these people had just protested, which means that the National Digital Health Management System updated a system just to punish the protesters. And Your Excellency, we believe that it is a right, a constitutional right of people to protest and speak about what they believe they needed or what the rights that are being not fully responded to. And before this, these people had actually sent complaints to the government of Jean-Pierre Havugimana and they were not responded to, which caused the protest in the first place. And when these people protested, they were suspended from food and medicine. This alone is a political discrimination, Your Excellency. And we believe that this Honorable Court finds it just to find the superior responsibility of Jean-Pierre Havugimana. May it please this Honorable Court. That is all for our rebuttals. Thank you. Thank you so much, Your Excellency. I understand truly your question, and I would like to clarify. I am saying on the fourth legal issue of extermination, we believe that Jean-Pierre Havugimana is criminally liable for the superior responsibility.
Thank you so much for the defense. This is your time for the rebuttals. Please have in mind that you should note all the questions that you've been asked by the panel of judges, as well as the prosecution team. You can proceed.
Much obliged, Your Excellencies. I, Counsel Rizikana Wasabiki, return to submit the rebuttals of the defense. We are, as the defense, prosecution deigns to claim offense before this honorable chamber. Counsel for the prosecution initially argued a Butara issue and not a Batura issue. It begs the question, was there a mix-up? Furthermore, the prosecution also established that killings could have continued. This is cause for speculation and not reasonable grounds as per the facts. What the court is here to decide on is what did happen, and the facts do not show the eminence of a continued killing spree that is, as the defense submits, not even correlated to the defendant. Substantial grounds for intent were not established by the prosecution. And as the prosecution would like this court to keep speculating, this chamber to keep speculating, it is immaterial whether or not a judge's agent or secretary could have been held criminally liable or could cause a judge to be held criminally liable for his actions. In fact, this just leads us to argue that criminal liability is personal. Speculations on what and what couldn't be should not affect this chamber's decision. Furthermore, on issue 1, there was no Dolly specialist established and throughout the issues as submitted by the prosecution. Our arguments at the start, at the beginning of the defense's submissions, show that while there have been communications that could be construed as having or declaring genocidal intent, given the history of the Karuba community and country, it is inconsistent with what the defense submits. It is a question of interpretation. Facts before and after can help this honorable chamber to decide that there was no dolus specialis. I'll answer the question of His Excellency as I proceed with the rebuttals, that according to, sorry, I beg your pardon, just a quick, yes, according to international law standards, questions of linguistics do in fact hold a lot of water in court decisions. However, in this particular case, we do not have the direct and specific implication of these statements towards the harm of the Batura people. In fact, the ambiguous nature of them and the efforts of the government, as reiterated in paragraph 4, lead us to believe that these were statements made trying to favor the Batura people. Speculations and implications of the prosecution, in contrary of that, must and should be disregarded by this court. That is our prayer. Furthermore, on issue 2 of the deepfake campaigns, the prosecution alleges dehumanization of the Batura by the DeepSeek campaign. However, they failed to connect this campaign to the defendant. Jean-Pierre did not have a secret channel through which information was passed, as counsel 2 of the prosecution would have us believe. Mr. Jean-Pierre Havugimana is also not liable for these statements. Furthermore, as alleged by the prosecution, privacy and data protection are irrelevant as factors to the arguments in the prosecution submissions, because this court is not assessing data protection and privacy, but the dehumanization of the Batura, which they failed to establish. Furthermore, collection of data does not cause mental harm as advanced by the prosecution. It was reiterated as the international law's threshold in Prosecutor versus Static that it is not psychological harm that results from public media declarations do not constitute reasonable or admissible grounds of psychological harm by international law. I'll call on to the integrity of Mr. Jean-Pierre throughout the fact sheet and say he was all through the facts portrayed as an upstanding leader. In fact, a leader who was here to advance healthcare, who was here to advance protection of the people throughout the fact sheet. I'll proceed to the rebuttals for issue 3, where the prosecution has failed to address the third issue at hand. They did not show how the defendant is responsible for the NDHMS failure to deliver medication. Furthermore, on issue 4, the prosecution advanced the claims in paragraph 12 of the fact sheet, which are completely unrelated to issue 4. Issue 4 was addressing the failure to submit supplies or to provide supplies to the Mwara, to the 3 localities, including Mwara, which were not Batura residences. In fact, it shows that the Batura resided in the northern and eastern parts of the country as opposed to the central western part, as is consistent in paragraph 43. Karuba, Your Excellencies, is a state that constitutes of ethnic groups. Such classification as was made by the NDHMS and subsequent tools established by the technological advancement agenda by President Jean-Pierre Havugimana could not have been found to be inconsistent with what a good government would do to try and establish well-developed and efficient methods of governance, such as the protection of the Batura people who have been seen to be a minority, and the supply of different medication. The government had shortcomings, but did not have specific intent for genocide under Article 28B or crimes against humanity under Article 28C. We believe that the defense has managed to dismantle any grounds advanced by the prosecution on the claims they bring in front of this chamber to accuse the defendant, Mr. Jean-Pierre Havugimana. We still pray, as we did before, that these proceedings are terminated and that the defendant is granted unconditional release. We thank this honorable court.
Just to clarify a statement on the threshold of the harm that was committed by the deepfake campaign, you're literally saying that the defense is stating that there was no mental harm?
The defense, Your Excellency, thank you for your question. The defense does not claim that there was no mental harm. However, the defense is saying that this should not be recognized as a threshold for commission of genocide and crimes against humanity consistent with the Malabo Protocol provisions, because it is not recognized under international law as how it is submitted and shown in Prosecutor versus Static, that psychological harm caused by public declarations by the media do not constitute mental harm in the eyes of the law.
So, in your opinion, this bias that was created by the AI fake campaign, should we still attribute it or remove it from the President Havugimana?
We definitely submit as the defense that we should remove it from the claims and accusations that are being presented to this chamber by the prosecution, and as per the different documents submitted to this court, that it should be removed and disregarded and expunged from the accused.
Perfect, thank you.
Thank you.
Thank you so much to both teams, the prosecution and the defense. These were very good and insightful debates. So the court has heard the submission of both parties, and like we mentioned yesterday, we believe that the matters you have addressed to the court are going to be examined, okay? And then we will get back to you after due diligence, of course, and understanding the complex issue of the matter. We will get back to you after 40 minutes of recess. Thank you.
When you pull me okay. The wind can blow, but I won't break. No matter the pain, you never run away. And there's no world where I'm not safe, as long as you stay. I'm gonna be okay, as long as you stay with me. Won't you hold on when I try to leave? You don't play hide and seek. Your love is always chasing me. As long as you stay, I'm gonna be okay. The wind can blow, but I won't break. No matter the pain, you never run away. And there's no world where I'm not safe, as long as you stay. I'm gonna be okay, as long as you stay. I'm gonna be okay, as long as you stay. Feels like I won the lottery. Didn't have to pay a thing. When love is real, it's really free. Feels like you knew me all along. You wrote the lyrics to my song. I wanna sing it on and on. Why would I ever go back? Would I ever go back? Oh, now that I know what I have, never gonna look back. 'Cause life with you is more beautiful than anything I've known before. Life with you is like living every day in a brand new world. Loving you is easy when you love me like you do. It's not hard to choose, spending my life with you. When you took my hand, you stole my heart, tore insecurity apart. 'Cause I didn't have to hide my scars. Why would I ever go back? Would I ever go back? Oh, now that I know what I have, never gonna look back. Yeah, life with you is more beautiful than anything I've known before. Life with you is like living every day in a brand new world. Loving you is easy when you love me like you do. It's not hard to choose, spending my life with you. With you. With you. This life with you is so much better. You hold my universe together. And I might not understand it ever, but I get to be with you forever, forever. 'Cause life with you is more beautiful than anything I've known before. Life with you is like living every day in a brand new world. Loving you is easy when you love me like you do. It's not hard to choose, spending my life with you. It's not hard to choose, spending my life with you. face with that look in my eyes, like nothing could break me with God on my side. But life has a way to keep wearing you down, and before you know it, that fire burns out. I could give up, give in and say that it's over, but I feel your hand on my shoulder, and suddenly I'm not afraid. I'm gonna hope when all that I'm feeling is hopeless. Something inside of me knows that the best days are still yet to come. I'll keep going, trusting you moment to moment, building and breaking and growing. God, I know you've just begun. The best days are still yet to come. You say I'm worthy and I'm not alone.
Gimana, the pre-trial chamber of the African Court of Justice and Human and People's Rights has reached its judgment. There are trophies in front of us, and definitely you are wondering who is taking what. But before I come to the final judgment of the court, the tribunal would like to first give you a few comments before we proceed. In the address of the CEO of the Moot Court Forum, he mentioned the efforts and the prior initiatives that were conducted as they prepared for this day to arrive. You have all done a wonderful job. To all the participating teams, including those ones of you who did not make it to the final, we say thank you. You did a great job, and that paved the foundation for today's wonderful Moot Court competition. We want to be back to the essence of Moot Court competition and to remind that it's not just a mere inter-school competition, but it's a learning opportunity for each and every participating student on your own. Everyone on this bench has been a mooter like all of you, and that experience has shaped them into the persons they are today. I'll give my own experience. I started mooting back in 2016. It marks 10 years of that experience. I represented Rwanda before the Nuremberg Tribunal in a competition that brought together more than 32 countries that was opposing the best students in international criminal law. And during that time, our university, University of Rwanda by that time, won the 7th position out of 32 countries and the 3rd best team in written memorials. That experience did not stop by there. It raised awareness of what Rwanda can do, especially when we were opposing with teams that came from countries that had no trust and respect for lawyers coming from Rwanda. I got further opportunities to lead moot courts in Poland, in Italy, in 2017 and 2018, when I was doing my master's degree in the United States at the Fletcher School of Law and Diplomacy, Taft University. I was chosen to represent that prestigious school as a judge in Poland, whereby very many countries had come to participate in what they call the ICC Moot Court competition. Surrounded by other experts on my left and right, all of them have participated in moot courts, and that exercise contributed to their overall achievements as of today. Rosette has been my student. She has been mooting in this room, And she knows what this competition means until today, including the person who served as a registrar or court clerk today. Last year, she was mooting in this same room as a mooter, representing her school, UNILAC, in the ICRC-led IHL National Moot Court Competition. Same with my other colleagues from this side, Rodham and Evalistus from the Office of the High Commissioner for Human Rights, and my colleague from my far left from IPEACE. So we are very happy to see how Moot Court is changing the professionalism and instilling values of hard work, allowing you to conduct independent research to understand both national, regional, and international legal frameworks. And we appeal to your respective schools of law to continue doing this and learning from the best, because that best is available here in this country. So when you're here as a mooter, we want you to have an understanding that it's not limited to just a fictional case. Try to make it live. And that should be started by your own reputation as a mooter. When you stand in front of us here, what do you want us to remember about you after leaving this room? It is an opportunity that you cannot let go untouched. The competition demonstrates your knowledge in legal norms, your ability to research, but also your ability to translate legal texts into practical experiences. And that is what mainly the judges are looking for. When we are marking the competition, we stick to your knowledge and use of facts, we stick to your knowledge of law, and we stick to how you make your arguments structured, but also the quality of the arguments you're trying to make. One thing that we know for sure that challenges most of the mooters is the ability to remain steady when you are responding to the questions asked by the judges. And we have tried to limit the questions to allow you the opportunity to make your submissions so that we could be able to understand what you know in this field. It is also very important to acknowledge the fact that the organizers of the Moot Court have looked for a case that is representing the reality of what is happening currently. The use of AI and digital technologies. That is a timely conversation, and we thank you for having chosen that topic. There are a few comments from the judges, including the do's and the don'ts when you are mooting. I'll start with one key comment from the defense side. When you are defending your client, you don't need to find yourself in a trap to be the one incriminating them. You cannot address your client as the accused when you are defending. That is the language that we leave to the prosecution, because they are the ones who are here to prove the fact that the accused is guilty. So you, as the defense, you always have to respectfully address your client. One good standard is to refer to them in their names as Mr. Jean-Pierre or the former president, and other nouns that can bring them to life in front of the court, for the court to believe that we are dealing with a dignified human being instead of considering it as a subject of the case. For the prosecution, you cannot foresee what the defense is going to say even when before they mentioned it. You can foresee what they are likely to mention, but you cannot say that the defense is likely to present to you, Honorable Court, this and that. Maybe it's not even part of their submissions. How do you know? In one way or the other, maybe you are reminding them to raise that point and build it from where you left it. So your only task is to be bound by the written memorials and the facts of the case that we believe that were handed to all of you before the competition started. Another key point is with regard to reference to jurisprudence, which is one of the main things that we want to hear from you. When you're referring to jurisprudences, you need to pay enough attention. And the way you make a full citation of jurisprudences, I do believe that you got enough time to interact with your supervisors and lecturers, and that is something that you can revisit. And then be selective of the jurisprudences that you cite, especially before the court when you're competing. Jurisprudences from pretrial chambers are not subjected to be referred to. You're only allowed to refer to jurisprudences from the trial chamber and the appeal chamber if the case went to appeal. Otherwise, you are likely to be referring to a jurisprudence that was not even sustained in the appeal. Time distribution. Wow. Time distribution. This one man who can have an entire team on his back, speak for some 30 minutes and then you leave 5 to your colleagues. It sends a message. It sends a message. And it also gives a hint on how prepared you are. But we know again that for eloquency and other purposes, including making sure that the points are delivered clearly to the court, you may choose, but again, be mindful of how you distribute the time among the team members. It looks good when each one of the team members is given the opportunity to present and not just take 8 minutes and then I give you 1 minute. It is very frustrating when the court clerk is raising the paper and shows you that you're only remaining with 1 minute, or when the judge becomes aggressive and tells you your time is over, no more submissions. So to handle that, next time you need to see how you can equally distribute the time that is allocated to your team. All right, so that being said, the bench had a very difficult time to deliberate who is the winner, and then the chamber has deliberated in favor of the what? In whose favor? Being mindful that you both did a great job, but at the end of the day it is called a competition. When it is called a competition, there should be the winner. But exceptionally in this case, there is no loser. There is a winner and there are many learners. You all learned a thing or two. No one of you lost anything. Silvio, you didn't lose anything. You all won at different levels. So the winner, the overall winner of this inaugural National Inter-University Moot Court Competition 2026 is today's defense, which is University of Kigali. Congratulations, defense counsels. Congratulations, University of Kigali. I think you are the best example of what a landslide victory represents, because the awards of marks that were given by individual judge shows a very slight difference. The prosecution registered 83.28, while the defense registered 83.29. So it was a tough competition. It was almost impossible for the judges to decide, but the way justice works, if you have two opposing sides, one of the two has to win. And there were multiple considerations. There were multiple considerations in arriving to that conclusion, that in most of the moot court competitions, the moot case is tailored in a way that favors the prosecution. That is very well known for all of us. And when you happen to get a defense that is able to work around such complicated facts and be able to sustain the arguments, they win the competition. We have individual marking sheets representing the marks that were awarded by each member of the bench. To show you the independence and partiality of each one of us, no one knew what another awarded, not until we went for deliberations and we put together all the individual marks that we awarded individually. So the average of all we gave as 5 judges is what led to that total of 83.29 for the defense and 83.28 for the prosecution. Therefore, the defense becomes the winner of today's competition. We had the task of deliberating on the best speakers, and the overall best speaker for males is Mr. Of course it's for males. It is Mr. Carl D. Civilli, who was the lead prosecutor for the Council for Prosecution. He was chosen throughout the whole competition as the overall best speaker for males. And the overall best speaker for female contestants, again throughout the competition, not for today's final. This considered what you did prior to this final competition, including what you had yesterday. The bench has come to a conclusion that the overall best speaker for female contestants is Igabe Salatini. Fair enough, I didn't even know you, I didn't see you before, and you were not part of today's motors, but the bench has considered your previous performance, and we came to a conclusion that you are the best speaker for females. The bench was also tasked to determine the best written memorials for both prosecution and defense. It was observed that the best written memorials for prosecution came from Ines Ruhengeri. Congratulations. And the best written memorial from the defense is from Unilag. We had the best speakers for today's final competition as well, in both males and females. The best speaker for male contestants, again, is Carl D. Civil, whereas the best female contestant for today has been Rosendana Owaseviki. And that leads us to the end of our remarks. It has been observed that the accused now, Mr. Jean-Pierre Havugimana, should be acquitted because the court is not convinced beyond reasonable doubt. We do not have sufficient reasons to believe that he committed all the 4 counts of genocide and crimes against humanity. Thank you so much, and congratulations to the winners. Before we give it back to the moderators, if any of my colleagues have additional remarks, we would open the floor, and then we'll leave it back to you for the program to proceed.
Well, to all the Moonters, congratulations. Congratulations to Unilag University. Congratulations to the University of Kigali. I want to bring up only one remark that I want you to take home. If you don't take anything else, at least from this whole competition, I want you to remember that when you are treating cases, They are cases for the clients, they are not your own cases. So always avoid emotional attachment towards the case. Is it clear? So being offended, for example, is something that should be basically, and I want to emphasize it, avoid it in court, okay? Because sometimes when you start practicing and you hear what the defense side says, there are some people who get emotional to the point of sometimes getting frustrated or even to the point of crying. You don't have to reach there, okay? You have to remember the case is for the client, okay? And then, of course, time management, as he mentioned, that's something. Can we have order, please? Yes. Time management is something that you should always have in mind, specifically when you are mooting. My co-judges are going to continue. In the meantime, it was a well-deserved win, and you won with such prowess, starting from the best male speaker, female best speaker, best teams, best memorials. You did a great job.
Okay. Even me, I can say congratulations to all the teams, not for those who are on the finals. Even for the previous team who did yesterday, I could say everyone did well, but by the end of the day, you know, we have to know who is the winner. And again, we don't need to take it by heart that maybe I didn't win. I could say a moot court competition is something you need to learn from. Apart maybe saying like, maybe I took the trophy to the university. As Karina said, even me, I've been a mooter for quite a long time. And I could say it's something which shapes you for the future. The way you present yourself, the way you appear before the jury, it's something which is, I could say, very relevant. Maybe, let's say, if you want to become an advocate, it won't be new to you because now, I can say, even the gown, you are used to it. Some of your classmates, they don't have them. I can say it's a privilege. And then I can say also, don't say like, this is the last moot court competition. We have even those prepared at the African level, even regional level. I encourage everyone to keep on applying so that we can keep making Rwanda proud, because I believe like now we have the content, knowledge, but what is missing is the initiative to say maybe it's my time to go and apply for this moot court competition. And the more you apply, the more you get more skills. The more you do a lot of moot court competition, the more you get a lot of knowledge. Otherwise, everyone did well. As they have said, it was even hard to reach to the conclusion. Yeah, I wish you all the best in the future.
I wouldn't want to repeat what colleagues have said already, which is very elaborate. I just want to congratulate the finalists. I think you've done very well. And I was just telling them when we were deliberating, it was a very tough one, that I see top human rights lawyers, not just lawyers globally, but human rights defenders. And for today's finalists, I have a little present for you. It's a little pin of the Office of the High Commissioner for Human Rights. I think some of you here would want to one day pursue a career in the United Nations system. So I'm seeing people who potentially replace some of us on the bench. So I'll give this to each of you, finalists. It would be a take-home for you to inspire and use it as a source that would permit you to think bigger beyond this room, because I see the potential in you. And I think that beyond today's competition, you have a lot of potential, and there's a lot to achieve from each and every one of you. On that note, I wish to thank you, and I wish you the very best in your educational career. And we'll be very happy to accompany most of you in the room, not just those who are privileged to be in the finals. Thank you, and wish you the very best.
Thank you very much. Just very brief, talking about building careers in human rights. I could tell that human rights citations was lacking in these presentations and in your arguments. So subsequently, you should be able to fetch from other sources of money. Thank you very much and congratulations.
All right, so that's it from the bench, and we give it back to the moderators. Thank you.
Okay, can we give a final round of applause to the winners? A louder one, guys. Okay, so moving on, our president of the Moot Forum is going to start the award ceremony, and he's also going to call upon the people who are going to award.
I would like to call all the partners here to make sure that their burners can appear, because they have done a lot. They have did so many things. They did many things for us to be gathered today. So we need to make sure that they are satisfied at the end. So we're going to commence with the awarding ceremony of the awards handling. I'm going to call the winning team to be ready, and you can go in front, but wait a little bit. So I would like to call upon the ILPD Vice Rector in charge of academics and research affairs, Dr. Yves Higas, to come in front and hand the bigger trophy to the winning team. I would like you to, the winning team, step forward. Make sure you smile. Those are winners of our inaugural National Inter-University Moot Competition 2026. Yes. Who's next on the agenda? I call upon the UNHCR Associate Protection Officer, Jovia Kailangwa, to step forward and hand it to our runner team. Australia team step forward. Yes. They are the second out of 5 universities. They did a great job. Yes. Now to our best male oralist of the entire competition. I would like to call upon the UN Human Rights representative, Judge Evaristus, to step forward. Step forward and Carl. No. Yes. It was going. Yes. A round of applause to our overall best speaker. Overall best speaker. In the high standard, high level of persuasiveness. Yes, thank you, Judge Evaristus. Yes. And now to our best female oralist of our competition. Step forward. Yes, and I'm the one to do this. That was her dean. Yeah. Can't leave him behind. Yes. A proud dean. And we now go down to the awards for the best memorials. And I would like to call upon Judge Rodham to step forward and give this award to the team, the whole entire team. Please stand. It's Ines. Please don't forget it. Yes, they won the best prosecution memorial. Yes, and now to call upon, yes, the Dean of Law from Ines Ruhengeri to come forward and hand this trophy to the team that has won the Best Defense Memorial, which is England, the whole entire team. Be proud of yourselves because you are taking so many trophies. Yes. Let's now do this very quickly. We're going to call upon the names of all the Mootas. Those ones we've been together for the preliminary round and for the final round. There are 14 in total. And they are going to be given their certificates of participation. Certificates for participation. call the name. You come forward first. Yes, the first motor is Udahemuka Paterne. Please come forward very quickly. And you come along with Judge Rosette. Yes, and the next judge is Dr. Nelson. Please come forward very quickly. With Akuch Kul Papiti. Yes. And the next motor is Carl D. Sivili. Please come forward with Judge Kalinda. And with Judge Rodham. Judge Rodham to hand it to Council Kamikaze. Yes, Council Kamikaze. And Judge Evaristus. Come forward with Council Uwase Viki Uzidana. Yes, Judge Evaristus, we request you to remain there. Yes, yes. With Angelo Kavi, Isingizwe. Council Kavi. You stay there as well. Council Judge Evaristus, you stay there with Council Sharon. Yes. With Council Sharon. And Judge Dr. Nelson, we request you to step forward with the Igabete Di Valentine, Council Igabete Di Valentine. And we call upon Iriza Alpha from HDI Render to step forward with Council Mutamba Fiona. And Iriza, we request you to remain there. With the Council Stacy Amvuta. Also, we request Council John Black Robert to step forward and the Alpha. Yeah, you stay there, remain there. And also, we call upon the Dean of Law from Ines Ruhengeri to step forward and hand it to Council McCall, please. Yes. Dean, we request you to remain there. And with Councillor Boy Dikomana. The Dean, of course, you're still needed. With Councillor Roda, straight forward, Councillor Roda. Yes. After that, the Dean may go back to his seat. Yes. After this awarding ceremony, there is a special item on the agenda. I request all the mooters, first the finalists to come here, line up, you take a picture. Yes. Wow. That's good. It looks good. Yes, thank you very much. And I request that these banners can be removed. The pull-ups banners can be removed. We are done. The pull-ups can be removed. Yes. We are coming to our closing remark. I would like to call upon the IEPD Vice Rector, Dr. Eve, to come and give his remark.
Thank you. I'm in a bad position. I'm the only problem I have on before lunch. Yes, thank you very much, MC, honorable judges, founder of the Moot Court Forum, distinguished university and faculty leaders, representative of Moot Court Forum, distinguished legal practitioners. persuasive advocacy, and respect for the rule of law. Every one of you leaves this competition better prepared to serve justice than when you arrived. The theme of this inaugural competition, technology and human rights, advancing access to justice, accountability, and digital inclusion in Rwanda's hybrid legal system, is both timely and visionary. Digital technology continues to transform every aspect of our lives. Artificial intelligence, digital evidence, cybersecurity, data protection, online freedom of expression, and algorithmic decision-making are no longer issue of the future. They are today's legal realities. These developments require lawyers who are capable not only of interpreting law, but also of ensuring that technological innovation advances justice while safeguarding human dignity and fundamental rights. Yet, as we reflect on the future of legal practice, we must also reflect on the future of justice itself. Rwanda is undertaking one of the most significant transformations in the administration of justice since the rebuilding of our institutions. Guided by the national policy and the aspiration to build a justice that is more accessible, efficient, inclusive, and responsive to the needs of our citizens, our country is progressively moving from a culture of litigation to a culture of mediation, and from retributive justice to restorative justice. This transformation represents more than the introduction of new legal procedures. It is a profound shift in legal philosophy. Justice should not always be understood simply as determining who wins and who loses in the court. In many situations, justice is better achieved by repairing harm, restoring relationship, encouraging accountability, giving victim a meaningful voice, promoting reconciliation, and rebuilding trust within communities. Litigation remains an indispensable pillar of every constitutional democracy. Courts will always play their central role in interpreting laws, protecting rights, and resolving disputes. However, litigation should not be the first or the only response to every conflict. Whenever appropriate, mediation, negotiation, conciliation, arbitration, plea bargaining, victim-offender mediation, and other restorative justice mechanisms provide solutions that are often faster, less adversarial, more cost-effective, and more sustainable for society. The legal profession is therefore evolving. The lawyer of tomorrow will not be judged solely by the number of cases won before the court. The lawyers of tomorrow will be equally recognized for preventing dispute, facilitating dialogue, building consensus, restoring the relationship, and contributing to lasting peace within society. This revolution demands a corresponding transformation in legal education. Today, I wish to make a sincere appeal to all universities represented here. Let alternative dispute resolution cease to be regarded as supplementary topic within the law curriculum. Let it become an essential pillar of legal education. Every law graduate should have, every law graduate should leave university equipped not only with litigation skills, but also with practical competencies in mediation, negotiation, arbitration, restorative justice, client counseling, and consensus building. These are no longer option skills. They are indispensable competencies for modern legal practice. I also wish to challenge our students: continue to perfect your advocacy before the court, but equally strive to become skilled mediators, thoughtful negotiators, ethical problem solvers, and be peace builders. Society increasingly needs legal professionals who can resolve disputes before they become conflict, who can unite to where other divides, and who understand that justice is ultimately about serving people. At the Institute of Legal Practice and Development, we fully embrace this national vision. As Rwanda's primary institution dedicated to professional legal training, IRPD remains committed to prepare legal practitioners who possess not only legal knowledge but also practical competencies, ethical values, and professional adaptability required by a modern justice system. We shall continue to strengthening our program in alternative dispute resolution, mediation, restorative justice, negotiation, and other innovative approaches to dispute resolution. We also reaffirm our commitment to working closely with universities, the judiciary, the Ministry of Justice, the Rwandan Bar Association, and our development partner to support this important national transformation. I would further encourage to the organizers of this excellent competition to continue innovating. Future edition should not only feature traditional appellate advocates, but also incorporate mediation competition, negotiation simulation, restorative justice conferences, client counseling exercise, and other forms of alternative dispute resolution. In doing so, we shall produce legal professionals who are fully equipped to meet evolving demands of Rwandan justice sector. Dear students, never forget that the greatest lawyer is not necessarily the one who argues the longest or speaks the loudest. The greatest lawyer is the one who uses the law to solve problems, protect rights, restore dignity, and strengthen peace. Your generation has the privilege and the responsibility of shaping the future of justice in Rwanda. I have every confidence that you will do so with integrity, wisdom, professionalism, and an unwavering commitment to the rule of law. Finally, let this inaugural competition be remembered not simply as an event, but as the birth of a national movement dedicated to excellence in advocacy, innovation in legal education, and the promotion of justice system that is people-centered, restorative, and responsive to the challenges of this century. With these remarks, I once again congratulate all participants. Thank everyone who contributed to this successful competition. Wishing you a safe travel, and officially declare this inaugural National University Moot Court Competition 2026 closed. Thank you very much. Murakoze.
Does anyone remember the phrase I taught them yesterday? No? None of you? Okay, so it's Jakanaka Kuapano. So turn to your neighbor and say, Jakanaka Kuapano. It means it's good to be here.
Yeah, we go Jakanaka Kuapano. Yes. Okay. Yes, I was just trying to bring a bit of home in the room. But thank you once again to everyone who made today possible. Your attention, please. Thank you once again to everyone who made today possible and to all of you for being part of this memorable occasion.
So what can you do about it?
It has been an absolute honor serving as your master of ceremony. And with
like
that,
to throw you
the
a party?
2026 Inaugural National Moot Court Competition comes to an end.
Invites all
Good day.
sent.